Okay, welcome. This is the June 7th, 2023 LUC meeting. Aloha mai kako. Good morning, everyone. This is an in-person meeting which is being held at the Maui Arts and Cultural Center, Haynes Meeting Room 1, Cameron Way, Kahului, Maui, 96732. Oh, and it's open to the general public. Court reporting transcriptions are being done from the Zoom recording of this meeting. That means we don't have a court reporter here. Accordingly, all meeting participants, I'd like to stress the importance of speaking slowly, clearly, and directly into the microphone. And before you speak, and each time you speak, I ask that you state your name and identity for the record. Even though this is an in-person meeting, please be aware that all meeting participants are being recorded on the digital record of this Zoom meeting. As I said, this is for court reporting purposes. Your continued participation is your implied consent to be part of the public record of this event. If you do not wish to be part of the public record, you should exit the meeting now. I will also share with all participants that we will take breaks from time to time, typically 5 or 10 minutes every hour or so. We'll also take a break for lunch. My name is Dan Giovanni, and I have the pleasure to serve as the LUC chair. We currently have 9 seated commissioners. Along with me today are Commissioner Lee Ohigashi from Maui, Commissioner Gary Okuda, Mel Kahele, Kuiki Kamakea Ohelo, and George Ata from Oahu, and Commissioner Michael Yamane from Kauai. Commissioners Brian Lee and Commissioner Nancy Cabral are excused from today's meeting, so we have 7 of the 9 here today. Also in attendance are LUC Executive Officer Daniel Orendanker, LUC Chief Planner Scott Derrickson, LUC Staff Planner Riley Hakoda, LUC Staff Planner Martina Segura, LUC Chief Clerk Ariana Kwan, and in attendance today also LUC Attorney General Dan Morris. Again, court reporting transcriptions are being done from the Zoom recording. Our first order of business is the adoption of minutes from the meeting of April 26th, 2023. Ms. Kwan, has there been any written testimony submitted on the April 26th, 2023 minutes?
No, Mr. Chair.
Thank you, Ariana. Are there any members of the public who have signed up to testify in the adoption of the minutes?
No, Mr. Chair.
Thank you. Commissioners, are there any corrections or comments on the minutes? If not, is there a motion to adopt the minutes for April 26, 2023?
Mr. Chair.
So moved by Commissioner Ohigashi. Do I have a second?
Second. Yeah.
So moved. Seconded by Commissioner, who was that?
Anthony.
Gahele. Okay, thank you. All in favor of adoption of the minutes, please say aye. Are there any opposed? Hearing none, no opposed, the minutes are adopted. Thank you very much. The next agenda item is the tentative meeting schedule. Mr. Orendanker, would you please share that with us?
Thank you, Mr. Chair. On June 21st, we will be in Hilo for the Kamehameha School Status Report. That's A19807. On the 22nd of June, we will also be in Hilo for a Ben Corp Status Report A02737. In July, we currently do not have any meetings scheduled. Excuse me. In August, we also do not have any meetings scheduled. However, we are expecting some items to be brought to the forefront. So we would have requested the commissioners leave those dates open.
There were specific dates in August to leave open.
The dates that we have scheduled in August are, I don't know why my fingers are so fat today. August 9th and 10th and August 23rd and 24th. In September, we will be at HCPO conference at the Sheraton Waikiki on September 6th, 7th, and 8th. On September 20th and 21st, we are anticipating Hollywood Development to come before us on September 20th. And on September 21st, Waimanalo Gulch. And that takes us through the active calendar for now, Mr. Chairman.
Okay. Let me just confirm with Ms. Kwan, have you surveyed all the commissioners for their availability for these dates?
I sent an email and I'm still pending some response.
Okay.
Deadline is Monday.
Okay, let me encourage all commissioners to respond with your availability for those dates to Ms. Kwan.
Thank you.
Commissioners, do you have any additional questions on the calendar or dates? Okay, thank you. Our fourth order of business is the status and progress report on A07-773B, the WAIKAPU Development Venture for the island of Maui. A status and progress report and action, if necessary, by the commission in response to the recently submitted 2018 to 2023 annual report. The status report is being presented by WAIKAPU Development Ventures portion of the property. But EMMANUEL Lutheran Church is present as a party to answer any questions that the commission may have as well. Let me summarize the procedure for today. First, I will update the record. Next, I will ask the parties to identify themselves. Then I will recognize the written public testimony that has been submitted in this matter, identifying the person or persons or organization who has submitted the testimony. Next, I will call for members of the public who wish to testify on the WAIKAPU Development Venture Status and Progress Report. The members of the public will each have 2 minutes to provide their testimony and shall stand by after their testimony, respond to any questions the parties or the commissioners may have. When all questions have been completed, the chair will excuse the witness and call the next witness to enter the witness box. After completion of the public testimony portion of the proceedings, the chair would like the petitioner to provide its status report. The chair will then call on the county's planning department, the Office of Planning and Sustainable Development for comments regarding the status report. The petitioner will then be allowed to respond to comments made by the county and OPSD. The commissioners will ask questions of the parties at the conclusion of each of their presentations. At the conclusion of the parties' testimony, the commissioners' questions, the public will be again granted a second opportunity to provide public testimony in the same manner that was set forth previously. Once public testimony concludes, the commission will enter the deliberations regarding the status report to decide if any action is necessary. The chair would also note for the parties and the public that from time to time, I will be taking short breaks. Are there any questions on the procedure for today from anyone? Petitioner, any questions?
No, Chair. Thank you.
County of Maui, any questions on the procedure?
No, Chair. Thank you very much.
OPSC, any questions on the procedure?
No questions. Thank you.
Let me ask you, I actually prefer to do it opposite and I didn't do it today. Will you please introduce yourself for the record? So starting with the petitioner.
Thank you, Chair. My name is Jeff Uyoka. I represent WAIKAPU Development Venture, LLC.
Thank you. County of Maui.
Thank you. Good morning, Commissioners. I'm Mimi Desjardins. I'm a Deputy Corporation Counsel, and with me today is Kathleen Aoki, the Planning Department Director.
Thank you very much.
Thank you.
PSD.
Good morning, Allison Plato, Deputy Attorney General for the Office of Planning and Sustainable Development. Thank you.
Thank you, Ms. Cotto. Reference for the record, please be informed that the relevant records and documents pertaining to this matter can be accessed for review on the LUC website at luc.y.gov/boundary-maui/A07-773/. You get that, everybody? Okay. Do I need to repeat that for anyone? Thankfully not. Okay. It's specifically under the pending dockets tab. Interested parties are welcome to review the documents at your convenience. So is there anyone here from Emmanuel Lutheran? Could you please identify yourself for the record?
Microphone for the recording.
My name's Leaf Shoestrand.
Can you say that again, please?
Leaf Shoestrand.
Lee Shoestrand, thank you very much. Okay, commissioners, do any commissioners have any disclosures to make at this point in time? Hearing none, we'll proceed to public testimony. For members of the public, again, please be reminded that the commission will not be considering the merits of the petition. Rather, the commission is interested in learning about the current state of the activities related to the docket, including compliance with the conditions, and will consider whether action is necessary. I'll now recognize written public testimony in this matter. Ms. Kwan, has there been any written testimony submitted on this matter?
No, Mr. Chair,
How come you don't have a microphone?
because we're short microphones.
But we hear you clearly. It's amazing. Ms. Kwan, has anyone signed up to testify in person?
No, Mr. Chair.
All right. So we'll consider public testimony completed at this point in time, but I just want you to know that we will be giving the public a second opportunity if anyone's inclined to do that. So now, Mr. Ueoka, I'll go to you as petitioner.
Okay, thank you, Chair. If you don't mind, I'd like to share screen.
Yeah, before you start, can you give us a general idea about how long you will be taking for your presentation?
I think I can do it in less than 5 minutes.
Man after my own heart. Thank you very much. So why don't you proceed?
Maybe I don't know how to do this, but sorry. So WAIKAPU Development Venture project in WAIKAPU. Hey. Okay, so that's a location. You can see where Waiale Road is. Honopi Lani Highways above, Waiale Roads on the right side of the screen. Lounge, Drugs, and Foodland are those little dots at the top. I guess my mouse does work for this. So around here. Down here is the Waiale Elua project, an existing residential workforce housing project. And over here is Spencer Homes. I'm sorry, WAIKAPU Gardens. And this is the upcoming Wailuku Apartments project. So the approved project description under the 201H, it's 100% residential workforce housing projects. 80 units on 74 lots was approved, 68 single families and 6 duplexes, so 12 units there. The income group distribution is between 70% AMI and 140% AMI. So the background, resolution 18150 was a 201H approval in 2020. resolution 20-107 extended the completion deadlines for the project. That's the 201H project process through the county. So the current status, the project commenced construction through the installation of a 12-inch water line main and 7 or 8 fire hydrants on Waiale Road. That was around August 2022. I believe we tied into the county system this past week, so the water line should be powered pretty soon. Still got to get them approved and stuff with the county. The 2-lot subdivision is in process, as you're aware. The whole thing was owned by EMMANUEL Lutheran, and there was an approval granted to allow the subdivision and sale of a portion to WAIKAPU Development Venture for this project. So that's all in the works. There's going to have to be the lot subdivision and building permits and everything for the houses. That's kind of the next step. The project's been on hold for a while. We're working with the county on a subsidy and redesign of the project, and I'll get into that later. So the next steps, here we are today to update the state LUC. We're hoping for an extension of the completion of construction deadline. I know I have on there July 2027, but I think we're going to actually ask for September to line up with our requested 201H deadlines. And we want to update you on the 201H plans and specs. And we still need to go back to the council for that approval, and our funding, the subsidy grant from the county, is dependent on the 201H approval or modification, however you want to say it. So the proposed improvements to the layout. So market studies have shown on Maui a lot that Maui people want single family homes. They don't really like the duplexes. So we want to switch the 6 duplexes and turn them into 12 single family dwelling lots. That requires extra land. So the idea was there was this interior dead end roadway that we're going to get rid of and restructure the project. We're going to reduce the sidewalks and eliminate, there was a small pocket park in there. We're going to ask for eliminate that. And technically, because this project is 100% residential workforce housing, the park assessment requirements of the subdivision code do not apply to this project anyway. And that all allows us to take the 6 duplexes and turn them into 12 single family lots, which we believe people want. So other 201H modifications we'll be requesting. So we only want to do sidewalks on one side of the street, save some space, reduce some costs. Street trees, that's just more technical from a county subdivision standard, but right now they have to be in the county right away. We kind of just want to make them in the front yard. Right of ways are difficult oftentimes because there's utilities in that area, and trees, utilities, they don't always go well together. So we're hoping to have some flexibility to move around. Our plan was to have the county maintain the retention basin and the greenways in the hopes of eliminating an HOA. The need for an HOA, I should say. The council wasn't too keen on that when we proposed that to them. So we're not sure where we stand there. And we need to modify our zoning language in the 201H in regards to the duplexes. So it's kind of small, but I think you can kind of see generally, this is the old plan. And there's this road here and the park there. So instead we kind of just made the road straight across, and then the duplexes that were over here before, now they're just 12 single family lots instead. So it's similar, but a little different. And we are going to go into the county to ask for a change. So we asked the county for a $10.65 million subsidy. It works out to around $133,000 per unit. County recently passed Bill 107, which lowered the residential workforce housing prices, the sales prices. So that, along with the increased interest rates, the interest rates were kind of twofold of a problem. It costs more money for the developers to borrow. And with the increased interest rates, the affordable or residential workforce housing sales prices they go down also. So therefore the developer gets less and they pay more for a lot of things. And materials costs went up tremendously, as I'm sure you're all aware. And we're exploring restricted resale price periods and all kinds of stuff with the county, but that'll all be in our 201H approval. I can say that the project will keep the prices 70% AMI to 140% AMI. The breakdown is not changing. The developers want to stick with the original sales prices. So this is kind of what we're looking at. Things have changed recently. The county came out with their new AMI, median income for Maui County. It's 105,800, I believe. So these prices vary a little, but they're looking at doing 12 units in the 70 to 80%, 12 units in the 81 to 100, 40 in the 101 to 120, and 16 in the 121 to 140. So that stays the same. Deed restrictions, again, we're going to work on this with the county. We're still trying to figure it out. Chapter 201H has a pretty strong first 10-year deed restriction. It's really limits resale prices, encourages people to stay in the homes. So we're still trying to figure out maximum resale prices with the county. I won't waste too much of your time on this, but I just wanted you to know we are working with the county on this.
I mean, I appreciate that you don't want to waste our time on it, but it's actually a point of interest of this commission.
Oh,
So if
absolutely.
you could expand on it, I would appreciate it.
Absolutely, more than willing to. Most people don't want to hear me talk, so thank you. So the maximum resale prices in years 1 to 10 under chapter 201H, they're limited to the original cost of purchased. You can add on any cost of any improvements you made and simple interest on the original cost at 1% per year. So for 10 years, if a affordable or residential workforce housing buyer buys one of these 201H units from us, when they go to resell it, they basically are limited on the resale price. They're limited on who they can sell it. They have to first offer it to the county, then to a qualified land trust, and then they can go to another qualified buyer. So that's for the first 10 years. With the county, we're trying to determine what they want to see. Since they're giving or granting $10 million towards this project, we want to see what they want to do. We've heard varying things from the council. We've heard, one council member proposed a 50-year owner occupancy restriction, meaning you can sell it after 10 years for whatever price you want, but it has to be to someone who's going to be an owner occupant. We're not 100% sure on how that's enforced or how it looks, but that was the wish. And they wanted to see 30 years on a resale price restriction where it would probably follow 2.96, which allows 25% of the difference between the cost of, the appraisal at the time of the sale, which would establish market value at the time of the sale, and the appraisal, original sale, and the appraisal at the time when you're offering it for sale, the resale price. Yet 25% of that, you add it to what you paid for the house. That would be the limitation on the resale price. We're not sure how much the market actually tolerates something like that. We've heard anecdotally that other projects don't fare so well. People, they're afraid of a resale price restriction, a deed restriction for 30 years at that price. Our understanding is things change, families grow, people need to move, and it's really restrictive on that ability. So we're working with the county. We're looking to see what the mayor would like to see, the Department of Housing and Human Concerns, other council members. So that we're hoping will be vetted in our 201H approval, because we are going in for a modification to extend the time for construction for us. So this is what I was talking about, the owner occupancy. So for 10 years, it's already required under 201H. And we're looking to see for the 30 years how that'll work. And we're, again, checking with the department and the county. We really want to know what they want, as we feel they're the best representatives of what the people of Maui need and want. And they can tell us what's best for them. And we're willing to work to make sure something good happens out of this, as we recognize that there's a huge county grant here. So the other thing that Bill 107 did was, when it got into the pricing of the homes, it took into this concept of total housing costs. So currently, the way you calculate prices of affordable housing sales price guidelines, they calculate at 30% of gross income, and you project it out to figure out what the price should be based on 30% of your gross income going towards your mortgage every month. The council modified it with Bill 107 last year. So it also added your mortgage cost plus all of your total housing costs, which get into HOA fees, PMI, private mortgage insurance, homeowners insurance, a variety of other costs. That plus your mortgage cannot exceed 31% of your gross income. That served to with the PMI that served to greatly reduce the affordable housing sales price guidelines for residential workforce housing units on Maui. So that was another factor. We were looking into options on how to reduce those total housing costs, such as the elimination of an HOA, working with various lenders on the elimination of PMI. As discussed, you will technically have a lot of equity in the home on the day you close, in theory, because you're getting a lower sales price, but the market price is still really high. So hopefully the 20% will be there and the homeowners won't need to have private mortgage insurance. That's our hope. We need to work with the community and the lenders to get that concept vetted and better understood. So finally, our projected timeline here. We still need to go through with the 201H amendment. We're probably going to need to come back to you guys to get an extension of the timelines in the DBA. We need to complete our 2-lot subdivision, and we have to go through subdivision infrastructure plans and permitting for the 80 lots. That's challenging. And then we have to work on the house plans. We're hoping to get all that done this year. It's very aggressive. We're hoping it can be done. Housing's crisis right now, so we want to move forward quickly. In 2024, we'll probably start doing the actual subdivision infrastructure improvements, start processing the building permits for the 80 homes, and hopefully by the end of 2024, we'll start home construction on the 80 homes, one at a time or groups at a time. And at that same time, we're going to start marketing buyer applications, lottery, and the sales contract to comply with the 201H 2.96 or Chapter 2.96 Maui County Code requirements. 2025 to 2026, homes should be done. People can move in. That's the dream. But all of this, I got to put the caveat in. It's going to be contingent on all of our reviewing agency timelines. We're hoping we can get done in a reasonable time. So thank you very much. Appreciate it.
So there's a microphone. Thank you, Mr. Oka. So Commissioner, any questions for the petitioner on their presentation? No, I just clarified to go directly commissioners. No. Commissioner Ohigashi.
Mr. Uoka, it sounds like that a large part of your plans are contingent upon funding from the county council. What is the timeline for determination of whether or not that funding will take place? And are you going to continue to work on this project during that time when they are considering granting you that money? Because there's no guarantee that you're going to get it.
Jeff Uyoka. Thank you, Commissioner Uyoka. So yesterday, the FY24 budget for the county passed second and final reading. There is an appropriation in the Affordable Housing Fund for this project. The funds are contingent upon receipt of or approval of the 201H modification time extension to reflect what we discussed today. The ownership has stated that they're willing to move forward based on the appropriation in the county budget. Again, we are meeting with the administration and the mayor, and so far everyone seems supportive of this project. They realize the challenges that, the astronomical increase in interest rates has put upon this project and a lot of other similar projects, along with the cost of materials went up tremendously. So they are willing to move forward with the planning and I guess putting in more capital without a guarantee on the county funds.
I noticed in your submittal of, I think it was filed on May 12th, 2023, that it comes under Wailuku Development Venture LLC. What is it? called stationary, right? But it also has signatures of the Emmanuel Lutheran Church. My question to you is that, does this document also serves as an annual report for the Emmanuel Lutheran Church of Maui?
Jeff Uyoka. Yeah, that was our understanding. We realized it was bifurcated in 2019 and it's been complicated because the water line is the last, or I don't know if it's the last, but it's one of the requirements of the 2-lot subdivision. So we're still on the lot together. The lot has not been subdivided yet. And Emmanuel Lutheran's been a great partner throughout all of this, and we thought we could respond at once. And that was part of the confusion why there's an amended annual report. We had to do a little bit more updates to make sure all of the Emmanuel Lutheran stuff was covered in the second submittal. Thank you.
So this is under, I guess my question is, since it's under one request for a DBA, and I'm not sure how bifurcated it is or what state it is there an actual report on what Emmanuel Lutheran's plans are to complete their portion of this, of the original 25 acres? And I see you have a representative from Emmanuel Lutheran here, so perhaps because this is a request for a status, we can allow them to tell us what their status is, because it doesn't seem to be reported within your documents.
Jeff, yes, Commissioner Ohigashi, I much prefer if they're more familiar with their project. I'm more familiar with the WAIKAPU development venture side. Thank you.
Is it all right, Mr. Chair, to invite?
Yeah, so we have a representative from Emmanuel Lutheran here. Are you an attorney for representing them? Then I'll swear you in. So then I'll have to swear you in. So please state your name and affiliation again for the record.
My name's Leif Schustrand. My affiliation with Emmanuel, been a member since 1998. I've been the chair of the Board of Education there. My wife's a first grade teacher. My kids all went to school there. I'm currently the president of the congregation just recently, maybe a month ago. So
Very good.
and I've been on our little land use committee for 20 something years.
So will you swear to tell the truth?
Yes.
So please proceed to address Commissioner Ohigashi's question. Commissioner Ohigashi, can you rephrase your question directly?
My understanding was the status report indicated was filed on behalf of your church, and my question to you is, it didn't contain anything regarding the church itself or that portion of the property dealing with the church. Would you be able to provide us a status report as to whether or not construction has taken place, what things have been done on that property?
I can tell you what I know. We did back in the 2000s get a super nice set of plans designed, ready to submit for permit that kind of covered up the whole 25 acres. We couldn't afford to build that. It was definitely over designed. We kind of backed off of that, you know, the 2008 economic slowdown, all that. Our school lost a lot of enrollment during that time. And we're just trying to hang on. So now with things, you know, we're kind of growing, ready to look at building again. And of course, the pandemic, all that kind of stuff. So, what I want to say, like, what we didn't see is the pandemic actually brought a lot of kids in. We stayed open kind of. So our enrollment's been kind of through the roof. And now all of a sudden there's kind of a need to get moved. We've kind of sold part of the property that we're going to build on. So we have to go kind of completely through the planning process of getting a new set of plans, of getting permits. We're motivated to do that. There's a Lutheran Church Extension Fund that can loan us money for that purpose. They're coming to town this weekend. We're meeting with them. So we're kind of in the beginning stages, but we do want to move quickly. So
How soon would you be able to file a status report on your own to inform the commission as to what your plans are for that particular parcel and whether or not you are able to meet the deadlines? Because some of the deadlines may apply to both projects.
that's a great question. I don't know if I'm knowledgeable enough about what goes into a status report to do all that. We can certainly.
Will you be able to take it back to your board and your congregation and be able to communicate to the commission within 2 months to tell us what do you want? Well, what proposal of a timeline
Sure,
the commission may want to consider?
absolutely. We could do that.
And there won't be an order from this hearing, so this is just a request on one lonely commissioner on Maui, just to ask you. So I'm asking that if you can do that, it will greatly assist us as to how we deal with this whole situation. Because technically, if you bifurcate, the law says is that the jurisdiction for any modifications may come under the county because of the 12.5 below the 15-acre parcel. So we're not sure whether or not those would come. In addition to that, one of the statements made in the report indicated that condition 5 on highways and roads regarding participating improvement to the highways and roads, that the WDV, which is Wailuku Development Venture, is not required to doesn't apply to them. So then that means that Emmanuel Lutheran is required to do condition number 5. And if that is a part of the subdivision, then the cost will be placed upon Emmanuel Lutheran. The actual DNO doesn't say who is responsible, because, and the bifurcation, I don't think said anything who's responsible. But based upon what was the sale between the two of you that take place, it is the only way I get to read this is that you guys between yourselves decided that Emmanuel Lutheran is going to pay for all those improvements on the state highway. So if that is the case, we'd like to know financially if this requirement will be borne by you and if you guys can do it. And if not, how will this requirement condition be met? Given the fact that we're initiating, or DV wants to create this large subdivision or this new subdivision in this area. So those are the questions that I have when I read this particular part. And perhaps we can get a response from both WDV and Emmanuel Lutheran Church in regard to that. And knowing your position right now, I can sense that you wouldn't be able to answer that question at this point.
Right.
So let the chair go on record that he shares Commissioner Ohigashi's concerns. He's not expressing a lone expression of his own. So let me ask Manuel Lutheran if you can respond to our staff, our LUC staff on or before August 15th, 2023 to submit and schedule a status report for your portion of the property. And in your forthcoming status report, or when I mean agendize, would be a hearing such as this, in which you make a presentation on the status of your portion of the project. And we would expect questions such as the one that Commissioner Ohigashi just raised about the improvements to be addressed.
Okay,
Fair enough?
yes.
Instruction. Yeah, so the point of contact in LUC staff will be our executive director, Daniel Orendecker.
Okay.
Okay. Back to you, Commissioner Ohigachi, for anything additional. Okay. Commissioners, anything additional? Commissioner Okuda.
Thank you, Mr. Chair. This is Gary Okuda. Thank you, Mr. Uyoka, for coming here today to give presentation. Let me first frame my question with a statement of what I think is the law, just so that you can see why I'm asking the question. I'm going to read a portion from the case DW Ainalea Development LLC versus Bridge Ainalea LLC that's found at 134 Hawaii 187 at pages 211 to 212. The Pacific Third citation is 339 Pacific Third 685 at pages 709 to 710 2014 Hawaii Supreme Court case. And let me read the admonition or warning that the Hawaii Supreme Court stated in that case. And I quote, "Vacant land with the appropriate state and county land use designation is often subjected to undesirable private land speculation and uncertain development schedules," close quote, and that, quote, "such speculation and untimely development inflates the value of land, increases development costs, and frustrates federal, state, county, and private coordination of planning efforts, adequate funding, public services, and facilities," close quote. Okay, is that what I read an accurate statement of the law as stated in the Bridge Ainalea case?
Jeff Uyoka, you read it from it. I'm not overly familiar with the Bridge Ainalea case, but I'll defer to you on that one.
Okay, well, taking the admonition that if a government agency like the Land Use Commission gives certain entitlements or rights to develop, especially if there's promises to build affordable housing or workforce housing under HRS Chapter 201H, we have an obligation as a government agency, as the Land Use Commission, to make sure that these things are carried out and property is not just left vacant. Okay. What evidence in your status report has shown the financial ability of your client to develop any type of housing on the property, whether it's 201H or any type of housing? What evidence in your status report shows financial ability?
Jeff Uyoka, the status report actually doesn't get into the financial ability. I can say that recently, the membership group has evolved, and there is the ability to get construction financing for this project moving forward. it was on hold due to the changes in pricing and everything that we went over. And now with the county subsidy, it's a good possibility, a strong possibility. I won't say a guarantee, nothing's ever guaranteed, but it's a strong possibility that this project can be financed.
Okay, well, you do understand that one of the things that at least I look at, I'm not trying to speak for anyone else, just myself, looking at a status report is to determine whether or not, given the standard that the Supreme Court has laid out in Bridge Ainalea, whether or not the appropriate action, perhaps the mandated action that the Land Use Commission must take is to revert this property back to the original land use designation from urban, for example, back to agriculture, because there is the promised work has not been done, or the promised development has not been done. There hasn't been substantial commencement of the use of the property in accordance with the representations or the approvals. And we look to the status report to determine whether we should do that or not do that. Do you think it's important then that the status report contain admissible evidence that the agency can consider, that we can consider to determine whether or not your client in fact has the financial ability to carry out these promises that were frankly made to the citizens of the county of Maui?
Jeff Uyoka, thank you, Commissioner Okuda. I'm not sure how we can try and do something. I can say for this project, it was bifurcated in 2019. Work was started for the 2-lot subdivision. In 2020, the world hit a pandemic. A lot of stuff slowed down. We came out of the pandemic with interest rates we haven't seen in 20 or 30 years. Cost of materials are at the, I don't know, all-time high. So it's hard to say anyone is financially able to do this project. I will say for security for this commission, before the bifurcation was done, the 201H approval was completed through the county. It's an exemption from the zoning and stuff. So this project cannot move forward in any other fashion if it won't get the exemptions, the 201H exemption. So speculation, not such a great threat here as far as selling these lots at market or something due to the 201H approval. I beg you not to revert this property back to ag. It's not a huge project, but it's 80 residential workforce housing units for Maui that'll go to local families. And I don't know how bad it is on the other islands, but I know it's pretty tough on Maui to get residential workforce housing units built. So I really ask that you trust the partners' ownership here. They have put $1 million into an offsite water line already at their cost, and that's serving other projects on Maui. They've put in, I want to say, another $3 million in various costs getting to this point. So they are committed to it. It's just recently it didn't look good when the sales prices went down 20 to 30%. The materials costs went up 20 to 30%, and their cost of borrowing doubled or tripled. So financial tough right now. It's very difficult, but I am asking that you stick with them and trust them to move this forward.
Yeah,
Thank
well,
you.
Mr. Uyoka, reversion is not on the table right now. This is a status report, and please don't read anything into the questions I ask, okay? I'm just asking these questions in an attempt just for myself only to satisfy what I think, and I could be wrong about this, the mandates that the law requires of it, and I could be reading this all wrong. So, there's no request right now to revert the property, but I'm trying to give you the background of why I'm asking this question. But let me I'll tell you this, the reason why I personally ask for admissible evidence placed on the record from which we can take action in the future is you do agree that agencies must act only based on the evidence, not based on argument, right? I mean, we have to have evidence in front of us whether we take an action or affirmatively decide not to take an action. You do agree, right? We're quasi judicial. We got to do things based on evidence, correct?
Jeff Uyoka, I won't disagree with you,
Yeah.
Commissioner Okuda.
And you do agree that it's almost like a mantra or a common statement of the law that arguments by us lawyers, it's not evidence. I mean, what lawyers say is not evidence unless the lawyer is going to testify as a witness, correct?
Jeff Uyoka, absolutely, Commissioner.
Yeah, so do you think it's unreasonable just to ask that, you know, if you have these factual statements that you believe should be reported to us, that it be put in a form which is not simply arguments by counsel, but it's actually presented to us so it becomes part of the record that everybody, including people in the community, can take a look at?
Jeff Uyoka, absolutely, Commissioner. I just asked for some extra time, maybe for next year's status report, we can give you more information. As was asked earlier by Commissioner Ohigashi, the county funds aren't guaranteed. You know, we're in appropriation. We still have a lot of steps, so nothing's for certain right now.
Yeah,
Thank
but
you.
Mr. Royalco, and again, what I'm asking is just me personally. I'm not speaking for anybody else, but me personally, unfortunately, we've had other cases, status reports, where sometimes decades later, nothing, the promised affordable housing is not there. And, you know, people have told us, well, look, we really do need affordable housing, so don't revert things. Essentially, trust us. Now, maybe when the presentation is first made for boundary amendment, you know, a lot more discretion or leeway is given. But when, for example, a condition is not met, it's a little bit, not a little bit different, but the burden to present or show good cause shifts more to the applicant. You agree that's a reasonable way of viewing things, correct?
Jeff Uyoka, and I agree. I just would ask in this case, before you shift it too far towards us, please remember COVID. That was years and had big effects, and that was a chunk of our time. We had 4 years. I'd say COVID burned 2.5, 3 of it.
Yeah, but Mr. Uyoka, I don't want to engage in an argument here, but under COVID, construction activities were specifically exempted from shutdowns under the governor's repeated emergency orders, correct? Construction activities. The construction activities were treated as essential industries. So in fact, there was no prohibition or because of the governor's emergency orders to shut down or stop development projects, building housing, or anything like that. Isn't that correct?
Jeff Uyoka, and Commissioner Kuda, I mean this with all due respect. I'm not trying to debate or argue with you, so shut me off if you need to. But yes, if you were at the construction stage, you could move forward. We got our approvals we got through LUC in 2019. And you don't get a subdivision approval. You don't get your construction plans approved in a year. We weren't even close to getting to the point of construction. And while construction was allowed to continue, a lot of the county approving agencies were shut down to a certain extent, if not stopped. And the county also adopted its MAP system right after COVID was kind of released, and that caused some delays for County of Maui processing. So I understand what you're saying. I don't disagree, but for this specific project, I don't think it would have been possible to move forward due to COVID.
Okay, well, whatever the reason is, you do agree that you probably are not, your client is not going to be able to meet paragraph number 2 which is found at page 15 of the findings of fact and the order entered July 11, 2019, which requires, and I quote, complete the construction of the workforce housing project no later than 4 years from the date of this order. You're basically saying you're not going to be able to meet that condition, correct?
Jeff Uyoka, yeah, we're not gonna finish the 80 homes in 6 weeks.
Okay, and in your status report, which is dated May 10, 2023. But by the way, this presentation that you just gave, that presentation that you just gave on the PowerPoint, that was really not included in the status report that was filed May 10, 2023, correct?
Jeff Uyoka, yes, that is correct, Commissioner.
Okay, why wasn't it included if all of this is relevant to determining the status of what's going on?
Jeff Uyoka, Commissioner Kuda, we really ramped up. We did the status report. We had an idea moving forward, but we weren't sure on where the project was going until we had very lengthy and strong discussions with the county council.
Okay,
That's when a lot of this information came out.
Okay, let me read a sentence from the status report, and I'm going to ask you whether or not this sentence in your status report is accurate or not. It's found at page 4, and it gives an explanation about, this paragraph that starts with due to the COVID-19 pandemic and current economic conditions, and it goes on. Okay, but there's a sentence that follows. It says, and I quote, several agencies have not initiated their review of the plans or have not responded to resubmittal of plans, close quote. Did I accurately read that statement in that paragraph?
Jeff Uyoka, yes, Commissioner Okuda.
Okay, what plans were submitted to what agencies where you didn't get a response to the submittal of those plans?
I believe these are referencing when we send in the subdivision plans for the 2-lot subdivision, and also, any other grading plans we needed and other associated county approvals for the permitting process.
Okay, can you list the specific plans that were submitted which you haven't gotten a response from the agency? And then I'm going to ask you which agency hasn't responded to you, because maybe we can act like the concierge and try to get your plans, approved or find out what's going on with a delay. So what plans have been submitted to which agency where you haven't gotten a response to the resubmittal or submittal of the plans?
Jeff Uyoka, I need to get back to you on that, Commissioner. I'm not sure on the specific agencies.
Well, is your client trying to represent to us that it's the county's fault, and specifically the county of Maui's fault, or a department of the county of Maui that's holding up approval of your plans, which is holding up this development?
Jeff Uyoka, I don't think we're trying to blame anybody for anything. I don't think that's my client's idea. We're just trying to state there were certain delays. We're trying to get agency reviews. We can get you a more specific list.
Okay, so right now you can't tell me whether or not that statement that several agencies have not initiated their review of the plans or have not responded to resubmittal of the plans. You can't tell us whether or not that statement is accurate or not accurate, correct?
Jeff Uyoka, it's accurate. I just can't tell you specifically which ones they are.
Okay.
And things may have changed since May 10th. We'd have to double check.
Okay. Have you or anyone else reviewed the cultural impact analysis study, which was attached to your submittal? I believe that might have been attachment 1. I could be mistaken. That's the let me give you the specific reference. That's the, yes.
So I'm in search of a break. Are you within 5 or 10 minutes of completion, or do you envision going farther in the, take a break?
Yeah, maybe we can take a break now, but I will try to wrap it up within
No, no.
5-10 minutes after the break.
Okay, fine. So it's 10:15. So we'll take a 10-minute break. Come back at 10:25.
Okay, thank you.
Okay. 10:26, we're back on the record. Mr. Uyoka, let me just, one thing before I resume with Commissioner Higashi. I do not. No. Oh, pardon me. Yeah, y'all look alike. All Japanese, huh? So, Japanese lawyers all look alike, somebody said. So, Mr. Uyoka, I'm not including you in that law. But I would like to ask you, for your PowerPoint that you shared with us today, to make that available to our staff, if you haven't already done so. So we can make it part of our record. So let's resume with Commissioner Okuda.
Thank you very much, Mr. Chair. This is Gary Okuda. Mr. Uyoka, these few hopefully questions I have go to what was submitted to the Land Use Commission by your office on May 12, 2023 as attachment to, I believe it was your status report. And it's a document prepared by Honua Consulting titled Ethnographic Survey for the WAIKAPU East Subdivision number 3. And the document has the date March 2022. Let me first read what I believe is a statement of the law with respect to certain duties that the Land Use Commission has, so that it frames the questions that I'm going to ask. And these questions go to whether or not there may need to be a supplementation of the status report so that we comply with the duties imposed on us by this case called Kapa'akai versus Land Use Commission, which is found at 94 Hawaii 31. The Pacific Third citation is 7 Pacific Third 1068, a 2000 Hawaii Supreme Court case. And in that case, the Hawaii Supreme Court held that state agencies have an affirmative obligation to preserve and protect customary and traditional rights of Native Hawaiians, and that in that specific case, the Land Use Commission improperly delegated to a private developer its constitutional obligation to preserve and protect customary and traditional rights of Native Hawaiians. And just so that we place this case in the context, let me read from page the Pacific Third, page 1082, what the Supreme Court said as far as explaining why agencies like the Land Use Commission have this affirmative duty to inquire and check into these matters. And I quote, "In addition to specific statutory obligations, the LUC is required under the Hawaii Constitution to preserve and protect customary and traditional practices of Native Hawaiians. Under Article 12, Section 7 of the Hawaii Constitution," and the Supreme Court quotes this provision, "the state affirms and shall protect all rights customary and traditionally exercised for subsistence, cultural and religious purposes, and possessed by Ahupua'a tenants who are descendants of Native Hawaiians who inhabited the Hawaiian Islands prior to 1778, subject to the rights of the state to regulate such rights," close quote. This provision places an affirmative duty on the state and its agencies to preserve and protect traditional and customary Native Hawaiian rights, and confers upon the state and its agencies, quote, "the power to protect these rights and to prevent any interference with the exercise of these rights, close quote. And that's again from the Kapa'akai case at 7 Pacific 3rd at 1082. Was that an accurate statement of the law as I read it, Mr. Uyoka?
Jeff Wilka, I defer to you on that, Commissioner. I'm familiar with Kapa'akai, but it sounds like you read it accurately.
Oh, okay, thank you. And so what was submitted as attachment to the status report, the report prepared by Honua Consulting, that was intended to satisfy or present evidence so that the Land Use Commission could satisfy and do its duty as required by Article 12 of the Hawaii State Constitution and as emphasized by the Hawaii Supreme Court in Kapa'akai, correct?
Jeff Uyoka, and I believe condition 24 was added at the bifurcation, which required a cultural impact assessment.
Right, consistent with Kapa'akai and the Constitution. Now, in reviewing the study or the report, which is attachment 2, which I have referenced, persons were interviewed to determine whether or not there would be impacts with respect to the matters which the Hawaii State Constitution says that government agencies have a duty to protect, correct?
Jeff Uyoka, that is my understanding, Commissioner.
Yeah, and it looked like 2 people were interviewed in the study. What is the evidence in the record that was submitted to us, anywhere in the record, that these 2 people that were interviewed have knowledge and experience in customary and traditional rights of Native Hawaiians relevant to giving us the ability to make the decisions and carry out our duties as required by Article 12 in the Kapa'akai case? I mean, what makes these 2 people reliable or persuasive, or however you want to take it, as relevant witnesses?
Jeff Uyoka, thank you, Commissioner. I think, like anything, it's subjective. I believe Honua Consulting selected these individuals. Since Maui's small, I do know both of them. They're local guys, born and raised, but I'm not sure what you would want to see further. We relied on Honua Consulting's knowledge and just general background and expertise in this, why they chose those 2 individuals.
Well, is there anything in the report prepared by Honua Consulting which indicates what the qualifications or what the qualifications or the standards were used to determine who to interview to gather evidence about whether there is or there is not impacts which are relevant to a Kapa'akai or Article 12 analysis?
Jeff Uyoka, thank you, Commissioner Okuda. I'm not sure what they used for it, but it does state that Mr. Blackburn is associated with the project area through his lifelong residency in Wailuku, Maui, and Nawai'eha. It talks about Mr. Fujiwara. He's a lifetime resident of Maui, an active community member. He brings a helpful perspective of expertise on the cultural resources, traditions, and customs that exist in the project area. He does not believe that the project will negatively impact cultural resources, traditions, or customs.
But what's the evidence that these people are actually or have the qualifications, either age, education, experience, training, as either cultural practitioners or somebody who would have relevant knowledge to give the type of analysis which the Hawaii Supreme Court said we on the Land Use Commission, better take a look and seek out, otherwise we'll get reversed again. Because, for example, you could say I was a lifetime resident of Kailua, Oahu, where I grew up. I'm familiar where the beach is. I went swimming at the beach once in a while, but I would never claim that I was a cultural practitioner or anyone with real knowledge of what the cultural practices were or are in Kailua or the general area. I mean, I can point out where the heiau is, but just growing up in the area, I'm not sure if that would qualify me to give the type of expertise. So I'm just making a point that perhaps you might consider some type of supplementation going forward, because if the kapa'akai, if the analysis and the work that the Land Use Commission is required to affirmatively take is not present, that can stop even giving approvals on extensions if we don't have some evidence that complies with the requirements of kapa'akai and Article 12. My other question is this. I'm not saying the best evidence rule applies here, but are these the best people with the best knowledge to give the type of background information so that we can carry out our duties required by Article 12 of the Constitution? I mean, why were these people selected and not other people selected? Are these the people who have the best knowledge in the community about the area, or are there other people? My own personal view is I'm not sure whether the record is sufficient at this point where further action can be taken. So that's just a commentary. I mean, there's nothing pending in front of us right now, but that's just my point. Do you have any response to what I'm saying?
Jeff, we'll follow up with Honua Consulting again. They are the experts on this, and we defer to them that they consult with the proper people. They determine who to interview, and we trusted them. But I will follow up to see if we can find out more information.
Yeah, again, because the Supreme Court has said government agencies have an affirmative obligation. It cannot be delegated. The obligation cannot be delegated to anyone else. So, okay, thank you very much, Mr. Uyoka. Thank you, Mr. Chair. No further questions.
Thank you, Commissioner Okuda. Commissioners, any further questions over here? Commissioner Yamani.
Thank you, Mr. Earl. A couple questions. It's on the subdivision process. I guess, where are you in that process? And has the sale already occurred, or does a subdivision have to happen first? And is that a critical path for you to pursue the development?
Thank you, Commissioner. The sale's there. You got to wait till the subdivision's completed, of course, for county rules. So, but we're close on the subdivision. The water line, my understanding is that's the last big thing, and the 2-lot subdivision should be complete soon.
And so has the sale already been closed? I mean, financially
I'm not 100% sure if the sale is closed, but typically, for this one, my understanding is it closed in the sense that they both are entitled to the whole property.
Okay, so
Yeah.
do you know if financially any dollars changed? Was it purchased?
Yeah, yes.
Would you happen to know what the cost was of the purchase?
Thank you. $1,050,000 for the land.
Okay, and can you proceed without the subdivision, or can I assume that subdivision is a critical path? Without that, you cannot pursue the development, or can you? That is the question.
Jeff Uyoka, my understanding is you can submit, while the 2-lot subdivision is pending, we could submit the 80+ lot subdivision to get everything rolling. They can be reviewed concurrently within the county of Maui.
Okay, thank you.
Yeah.
No further questions, Mr. Chair. Thanks.
Thank you. Commissioners, anything? Commissioner Ohigashi.
At the risk of laying my hand out, my cards on the table is that I think that we should have this matter come back before us as soon as you are able to file a motion for the purposes of extending time. And one of the reasons why I'm looking at that is that the bifurcation order modified only two conditions. Condition number 20 and condition number 2. And condition number 5 seems to say that when the development of the church is completed, that the TIAR process would begin. And however, condition number 5 was intended for the purposes of calling it the project and was in there before the bifurcation occurred. So the question in my mind is, does condition number 5 require this subdivision or this new development to consider what impact does it have on the neighboring state highways by doing that TIR, and should it be required? And perhaps in your motion to extend time, that issue can be briefed and addressed. Second thing is that we're not sure, we don't have copies, I guess, of what the agreement is with the county. So the county, if they pass some kind of permit or they pass some kind of subdivisions, can include that condition as a condition for the purposes of the subdivision itself. Because for all of us who don't know, that street was pretty crowded during certain times of the day, and the impact of an additional subdivision in that area may require additional improvements. So that's what I'm thinking. I'm just thinking that. And the question is, then the question is going to turn, does that increase the cost of the subdivision? Does that, but those kinds of issues should be laid out before going ahead, because you're going to wind up with a whole exacerbation of the traffic in that particular area. I walk over there and I see it and I drive it and I know it. So that's my concern. And just my suggestion that somebody addresses that, and somebody means whoever's first up to bat, whether it's the church or the subdivision. Okay. That's not a comment.
Oh, do you mind if I respond?
I welcome it.
Okay, thank you. Thank you, Chair. Jeff Uyoka, Commissioner Higashi. Understood. That was why we responded the way it was. It was triggered upon the completion of the school and the opening of the school for condition 5, the TIAR. We can reach out to the state DOT and, talk with them. The difficulty is we're one of the last ones in on this, on Waiale Road. And it's an 80 unit, 100% residential workforce housing unit project. I'm not sure what the improvements will look like. That's my only fear with putting a condition like that on an 80 unit project. It could bury it if the requirement comes out too great. But again, like you said, we need to include that in the briefing, and I did submit a motion yesterday.
Yeah, let me clarify for the record. So the petitioner yesterday submitted a motion to our staff for, you want to summarize them? It has not yet been posted to our website. It's not fully understood by the commissioners themselves, but I'll give you a minute or two if you want to summarize your motion, but we're not hearing that motion today.
Thank you, Chair Jeff Uyoka. Yeah, we submitted a motion for extension of time and in the bifurcation order, it kind of stated the 201H specs and plans and specs application that were submitted with that were a representation moving forward. So we just wanted to, I guess, notify the commission that that would be changing also to put everyone on notice. And it's an unknown still because we have not received the county approval on the 201H modification. So just for clarification
And
there.
so, that then turns to my question is that, does Emmanuel Lutheran realize that if they build a church there, or school or what, if they have their plans be done there, that they will be responsible for all the improvements that you may have caused in this matter? I'm just, and I don't believe that, I don't believe that it was the intent of the parties to slough this requirement off, because everybody seemed to have been proceeding together in a joint fashion at that time. And so I think that everybody expected that these things would be done. And you increase, and the impact of this development does have that potential. So it's better to know than not to know.
The concern is that satisfying this condition may doom one or both projects. And it cannot be unclear who is responsible for fulfilling that condition. That's understood by both the petitioner and
Jeff, we'll reach out to Emmanuel Lutheran and State DOT and traffic engineer to see what the actual impact or see what the study would say for an 80 unit residential workforce housing subdivision and a school. It's difficult on the school at this point because they don't have their plans drawn up right now, so you can't really project traffic without a set base, but we can make assumptions. Thank you.
you good.
I'm just, it's up to them.
Commissioners, anything further? I have a couple of questions. Can I ask you to put up your PowerPoint again and your timeline? Any way to make that bigger? There we go. So of these points, particularly the ones in 2023, I'm interested in your go, no go decisions for this project. For example, if you do not get the $10 million subsidy from that county, does that mean this project is a no-go? So I'm interested in I'm not specifying what's go, no-go. I want you to specify what's go, no-go. So I'd like you to go through these milestones, if you will, and identify any of which are go, no-go, and also when you expect to reach that decision.
Jeff Uyoka, thank you, Chair. So the 10 million are some large amount of county subsidy. If we don't get any county subsidy, my understanding is the project is a no-go, in that it was in the process of being scrapped before the one of the ownership representatives worked at the county council and this process began again. The 201H amendment.
And the when on that?
Oh, so we started that beginning of May, mid-May. And the county council just approved on second and final reading their budget yesterday. So it is in the county budget. We still need to work with the mayor and the administration. To
So
figure.
it's weeks to months away.
Correct. Yeah, sorry. So the 201H amendment, we'd like to get our package together to the council. Within the next couple of weeks. We have some work to do trying to figure out the best process to the deed restrictions. The 10 years is already set by 201H, but the additional resale price and owner occupancy, we need to see what works for the council and the administration. So we're hoping to get that process started in the next couple of weeks. The approval for that, it's a resolution, so it would need to go to committee and then to the council. So that'll be at least 6 to 8 weeks, I'd say. We submitted that motion. We have a little bit of homework to do, additional information to get. So we'd hope we could get through this process with the LUC, I don't know, maybe by the end of summer, I'd hope. I'm not sure if that's overly optimistic. Either of those not getting through would be a no-go. If we didn't get an extension of time from you guys, in theory, that would probably mean you'd want to revert it or something. You're not supportive of the project moving forward. Without the 201H amendment, we wouldn't get the county funding and we wouldn't be able to redesign the project as we feel is better and I guess cost efficient where it could be built. To complete the 2-lot subdivision process, naturally, if that fails, it's a no-go, but we're pretty certain it's a ministerial process and we're closing up the last requirement, so that should be okay. Subdivision infrastructure.
And that's weeks to months also. Months to years, what?
With the county, I'd like to say weeks to months. Yeah, it's with the county right now, so weeks to months. Subdivision infrastructure plans and permitting, again, ministerial, so it should be approved. I'd say months, multiple months for approval. Naturally, if that is not approved, it's a no-go. We're not moving forward with the project. House plan development, it's going to be based off of the proposed subdivision plans. I'd say probably weeks to months to get that, buttoned down. It's, it really depends on the specific lot sites. In 2024, naturally, subdivision infrastructure improvements will go in. We're not anticipating it being overly painful. County water, county sewer. Naturally, if we don't get that, no go. Building permits, we're hoping, subdivision infrastructure improvements, that'll probably take at least 12 months, maybe more.
Which one?
Subdivision infrastructure improvements, yeah. Building permit processing, we're assuming that's months, and ministerial should be okay. Home construction, we can commence when we get building permits.
So the one I don't see up there is your construction loan.
Okay,
So when will have you applied for the construction loan?
I don't believe, we've been in touch with lenders. Our builder has a good relationship with lenders and it's being discussed. We have not sat down and anything firm yet, as we're still kind of in limbo a lot, but that would be a no-go again. If I'd give that weeks to months. Yeah, we would need the construction plans done, so months.
So you've identified 4 or 5, I think 5 go, no-go decisions that you'll be facing within the next few months. Is that correct?
Jeff will, yes, that is correct.
Okay. Shift gears a little bit. This commission is obligated by its own rules and by the interest of the state of Hawaii on any project development's impacts on our climate change. You're not a huge project in respect to some that would have a major impact. But I've noted that just in the changes that you are proposing, you're eliminating park area, green space. You don't want to do any landscaping in the right of ways now. Because you want to move trees to the center of the lawns or something of that sort. So I'd like you to assure this commission of what, or inform this commission of what steps you are taking as the developer to be respective of the impact that you might have on climate change, because you're taking agricultural land and you're covering it with a lot of concrete here.
Jeff Wioka, thank you. Just for clarification, it's just, we don't want to plant the trees in the county right away. It'll still probably be grassed or something.
That's
Yeah.
good.
Yeah, so
That's helpful.
yeah, it won't be, yeah. So the tree just will be in the front yard, so the roots don't interfere with utilities. We'll discuss that a little further. The park, you know, the park was recent. There is a big drainage basin that will probably be grassed in the property, and there's a greenway requirement, I believe, along Honoapiilani Highway. But you are correct. The park is now, the pocket park is not there anymore. It's going to be houses. We can try and check to see what the net loss of area is, in the sense that these houses will have yards and stuff too. So there will be area there. So we can definitely look into that further, Chair.
Do you know offhand if the design of the housing has proceeded to the point that you've made decisions about the supply of energy for the project?
That we, Jeff Wioka, we're not that far yet, Chair.
So you don't know if you're going to use solar power for the residences, or you're going to just buy from the utility electric power?
Jeff Wioka, it will be connected to Maui Electric.
And no rooftop solar being installed on these units?
We're not that far along yet.
Okay. Okay, I'm good on my questions for now. Anything for Commissioner Okuda?
Thank you, Mr. Chair. A very short follow-up question to the chair's question. Yeah, it would be helpful if your client, in whatever further submittals are submitted, if you can present at least some type of even very tentative, very tentative conditional loan commitment, just so that we can see, you know, to what extent this project is financially feasible or not, or whether the financing is feasible or not. I know, you know, you are correct that you cannot get a final loan commitment with a lot of these documentation and plans and approvals, but if you can give us at least an indication of that there really are or is a live lender there willing to lend on this, subject to, you know, conditions, but if you can show that, because otherwise we start, at least for me, I start running into the admonition of the Supreme Court in Bridge Ainaleo, which is it starts looking like land speculation and not a project, because we do want to see workforce housing. You know, if there's anything we can do to expedite workforce housing, we will try to do that within the bounds of the law. But at the same time, we're very cautious about what might be land speculation. And so if you can present evidence to show this is a project that really has the ability to succeed or be, you know, come to fruition, that'll be very helpful in us, you know, making the decision based on the evidence presented to us. Thank you, Mr. Chair.
Thank you, Commissioner Okuda. Commissioner Atta.
I'm glad to hear Dan talk a little bit about this global warming, climate change, and stuff like that, and the fact that the folks are being made to have greater density and stuff like that. They lose me park space, and I just that bothers me actually, because it's going counter to global warming and climate change. I was just wondering if you folks had maybe a little more thought into how you're handling global warming, climate change, because I didn't see anything in the paper, the work. Then so I don't know if you're gonna have greater less, not, more of a single family project, then where is, how are you addressing those big issues? In that,
Jeff Wilka, thank you. My apologies, Commissioner Arth. I was just checking. I think the park was less than an acre in space. And, you know, to be fair, this area, it is getting built out. I will say Mauka in the Maui Island plan, there's a 250-foot buffer between, that's supposed to be between WAIKAPU and Wailuku. That'll be all green space.
that's not
That's not our project, but just in general, in the general vicinity, there is a lot of green space. Our hope here is, again, our hope was the duplexes going to single family homes. It's really trying to just satisfy the wants of the people. And I understand global warming, climate change, it's very important, but that was the reason for these alterations, but we will definitely look into that and get back to you.
But you know that thing about you're saying that the people want more single family homes. Is that based on a market study of who are you talking about? Since this is workforce housing, right? So there's all kinds of people now, and with the climate change and everything. I don't know if people want the same single family house. So.
I will, it's anecdotal primarily, Jeff Uyoka, it's anecdotally primarily, Commissioner. It's different, it's not rental, and this project is for sale, but a block down the street, there's gonna be 324 apartments available in that area. We've heard anecdotally the projects, I believe there's a project in North Kihei. Granted, this is central, that was North Kihei. It was an affordable housing or residential workforce housing component of a project, and it didn't sell too well as duplex. It's just traditionally we found Maui, and I don't have a set market study, but traditionally we found that the single family product is very desirable here on Maui. Thank you.
Yeah.
Okay. Anything further? Going once, twice? Thank you very much. We're going to proceed. County of Maui, any presentation or remark you'd like to put on the record?
Mimi Desjardins. At this time, the county has no comments to provide. Thank you.
Okay. Commissioners, questions for the county? I have one. So we've heard from the petitioner about numerous things that are ongoing with the county. Can you comment on, from the county's perspective, what is the status and what's going on with your discussions with this petitioner about this project?
Mimi Desjardins. From council's point of view, we've had no discussions. I have sat in on various meetings and have seen the progress of what's happening and have looked at the modifications that have been requested in terms of timelines in the past. And I do understand that the petitioner will be asking the council for further time extensions. I do know that during the budget process, there was discussion about providing significant funding from the affordable housing fund to this project. However, it was conditioned specifically on time extensions being granted by council, and the council seems actively interested in possibly creating more conditions as part of the extension here. And some of those were raised in this discussion you've had this morning with the petitioner. But other than that, we don't have anything further to provide. Thank you.
So you heard the petitioner enumerate approximately a half a dozen go, no-go decisions that he'll be facing in the next few months, all of which involve the county of Maui. So you have a very important role to play in whether this project goes forward or not. So I would encourage the county to get actively involved. And if this matter comes back before the commission, we would be looking for the county to be as explicit as they can in updating us on the activities from your perspective.
And Mimi Desjardins. And I totally agree, and I can't speak for specific departments because there may be ongoing discussions that I'm not aware of. However, I think that a lot of that no-go discussion will occur when council is asked whether to extend the time on this and what they're willing to provide to petitioners or not. And that'll really be up to the members of the council.
Including the $10 million they've asked for.
Exactly, and which has been appropriated, my understanding, I don't know, was it 10 million? It's been approved in the budget contingent upon the time extension. And then we'll see what that discussion looks like, because of course, as you know, that could include other conditions to give the time extension.
No, fair enough.
Yeah, thank you.
Okay, commissioners, anything further? Thank you very much. Okay, Commissioner Okuda.
Yeah, just a comment to everyone. And if there's potential Chapter 343 environmental assessments which might apply, just me personally, I would urge that be taken care of more sooner than later, because if you have a worthy 201H project or any type of project that is going to benefit the community, we really hate to see it, die on the vine where a 343 issue pops up, which could have been taken care of a lot earlier. So if there's an environmental assessment that has to be done, please err on the side of caution and make sure something like that doesn't derail a good project at the very end. Thank you.
Okay. OPSD, Ms. Cato.
Thank you. Allison Kato, for OPSD. We don't have any particular comments, but we recognize that progress on this project has been very slow, but given the current potential for the subsidy from the county, we think it wouldn't be unreasonable to give additional time for them to work things out and see how that works out. Regarding Commissioner Okuda's mention of possible 343 triggering, we think that there is an exemption that might apply for the affordable housing under the new rules. So I just wanted to mention that. I'm not sure, I guess this is more of a question. I'm not sure if petitioner has considered HHFDC funding financing.
Commissioner, are you prepared to respond to that issue?
Jeff Wioka, thank you, Chair. Thank you, Ms. Kato. No, we haven't considered HHFDC. We're just got going with the county one, and it's hoping that'll be good and we can move forward with the county funding. Thank you.
Okay, I just wanted to raise that as another potential source of funding. I don't have any other comments. Thank you.
Thank you. Commissioners, any questions for OPSD? Commissioner Higashi.
I'm not sure, I'm not asking OPSD, but I'm asking the petitioner, what's the budget for the development of this project? What's the cost?
Jeff Wioka, I believe the last numbers we came up with was a little under 50 million.
50,
Yeah.
50.
50.
And so the $10 million infusion by the county would be 20% of your entitled budget.
I believe, Jeff, I believe so. It gets a little complicated because there are a lot of other costs up front that I don't go into that 50 per se. So yeah, 20%, give or take.
Further? Okay, thank you, Ms. Gato. I have no questions. Chair has no questions. This is our final call for public testimony on this matter. Once again, are there any members of the public who wish to testify on the status and progress of A 07-773B WAIKAPU Development Ventures? Seeing none, we'll proceed to further discussion. So commissioners, this is a status report. We're not required to take any action at this time. If no action is taken, the requirement of continual annual status reports will remain into effect. And I believe, let me just confirm with staff, when would the next one would be due if we don't take any action? Which was May 10th, I believe. Is that when the last one was dated? May 12th. So if commissioners, if we do not take any actions today, we will not see, the next thing we'll see is in terms of a annual status report will be next May. Now let's recognize that the petitioner has very recently made a formal motion to extend, and we'll probably take that matter up before the scheduled annual status report would occur.
Sure.
Let me just finish the opening remarks here. So however, if the commission feels that its concerns have not been addressed on the comments and responses that have been provided today, the chair will entertain a motion that either the petition status report does not sufficiently address the commission's concerns and that further meetings or status updates are necessary to provide the opportunity to do so at a future date determined by the LUC staff, or that there is reason to believe that the petitioner will not adhere to the conditions set forth in the DNO and request that staff move forward with a formal order for the petitioner for a show cause proceeding. Okay. So that's where we stand going into discussion. So Commissioner Ohigashi.
Yeah, maybe a question for our executive director. Given that my understanding of the status of the ownership of the property, that ELC and WDV both own it as a jointly at this point in time, would it be correct to say that their motion to extend time would have to be a joint motion or for both parties? I'm just, or have the permission of.
Mr. Oranegger.
Commissioner Ohigashi, we have two separate docket numbers on this. I think that from a legal standpoint, both parties would have to agree to the motion since they're both co-owners of the property at this point. However, since there are two separate dockets, it can be brought by one of the two petitioners. In other words, we have a requirement that the landowner approve or agree to whatever's being filed in front of us. However, in this case, since we have two different docket numbers, the party under which that docket number applies could actually make the motion, but it has to have the approval of the other landowner. My concern is I want to make sure that the ELC has full knowledge of their requirements under the term of this order as we proceed in this matter, and that they are able to fully understand what their obligations would be under any future order. So I just wanted to make sure that their participation can happen. Because I'm not sure, even if you make a separate docket, technically, there may be even parties to that docket. Given the procedural history that we have here where the WDV intervened into the original docket and got the bifurcation. So I am hesitant and feel a little protective I guess of ELC and their participation in this matter. But again, I don't represent them and neither does the commission. So I just want to note that for
Commissioner Okuda.
Yeah, if you don't mind, I'd like to second what Commissioner Ohigashi has stated. I believe this is like the cousin to the indispensable party rule. We don't want inconsistent results. It's also a due process issue. And if there's a necessary party that is not participating and showing full knowledge and consent of what's taking place, then even if the petition looks good, we might not have the power to approve it because somebody's rights who's not presently a party is being affected. So I think out of an abundance of caution, what Commissioner Ohigashi suggests is something to think about, just so that we don't run into this due process indispensable party issue. Yeah. Thank you, Mr. Chair.
So commissioners, I would like to speak my mind a little bit to you and give you an idea that we may consider on a going forward basis. So this is open discussion at this point. It's not a formal motion, but it appears to me that we have a need for a status of the Emmanuel Lutheran property. And we've got a commitment from the representative to inform our staff by August 15th or sooner of when we can agendize. So that's like 8 weeks away, when we can agendize before this commission a hearing to receive that. In parallel with that, and in that same time frame, the immediate petitioner has told us that over that same period, he's got a half a dozen go, no-go decisions that will inform the petitioner whether they're going to go forward on this project. And will have a very significant bearing, in my opinion, on your motion for extension. You may even withdraw it. So I'm wondering whether we could, in some way, request that the two parties come back at the same time. One, to give a status report on their project, that would be Emmanuel Lutheran. And the second would be for a formal presentation on the motion for an extension. And at that time, we would hear it. And let's elaborate on what I think they heard it once already, but what our expectations would be at that point in time. But we're basically looking to something in the next, say, 3 months from now, where we'd invite both parties back jointly with some common goals. Number one, to get a clear understanding of what the church is planning to do. Secondly, how you can assure this commission that none of the original conditions are falling by the wayside and being lost in the transaction. You can give us a clear update on the financial transaction between the parties and whether that is closed. You can give us a clear indication on the go, no-go decisions that you faced and the progress that you made. You can give us a clear indication from the County of Maui and how you have progressed. We would invite the County of Maui to give us a more detailed presentation on their view of this project. Because I think the message we're trying to send is, at least coming from the chair, is this could be a very important workforce housing project for Maui, and there's no question about the need. If anything, we want to assist to make it successful and to keep it on track and to give you what you need. But there's some balls in the air here and they're being juggled. And I'm not sure who the juggler is, and I'm not sure how many balls, but we need to understand all that, right? So commissioners, that was a message to you, should I let them over here? Do you have any?
Mr. Chair,
Yes,
they pay you, they must pay you the big bucks to be the chair over here. So,
I don't pay nothing. It's
anyway.
a volunteer job, you know that.
I see your suggestion and one of the, since we don't have technically, we don't have the motion in front of us to schedule something. I suggest this is that we continue this status hearing for a period of time of 3 months. And to schedule a status hearing on ELC at the same time. If Mr. Kawada's motion is necessary to be heard, he can petition to have that matter heard within the 3 months at that same time. So that's my suggestion, rather than waiting 1 year from now. To take it.
Oh, totally,
Right.
yeah.
So I'm going to make a motion to that effect.
I don't think we even need a motion. I
Okay.
think I could just ask the staff to.
That's
execute.
fine. You get the big dollars.
Yeah. Well, the big dollars he's talking about are the 2 lemon bars he brought me today. Which I appreciate, by the way. Commissioners, any further comment on the notion before us? Make sense? Okay, so the chair requests that the LUC staff work with the parties on both dockets to schedule and agendize at the same hearing, same meeting date, in which we would hear a status report from Emmanuel Lutheran. And secondly, we would hear on your motion for an extension. And consistent with that motion, we're looking for a more detailed status report on on all of the issues that you heard surface today. And I'd also encourage you to, on matters that you may not personally be fully up to speed on, bring some witnesses like this consulting group that's doing the cultural study work, the traffic stuff. Whoever, that's very helpful. And because we don't want to put any unnecessary further delay in the project. But if the answers to pertinent questions are, well, we'll have to go get you answers, that's a delay. So we encourage you to bring all the expertise at the time and schedule that with our staff. And the point of contact is Mr. Orendanker, our executive director. Fair enough?
Mr. Chair, may, for clarification, for everyone's clarification, we will be contacting you and we will also be sending out a letter with containing some of the questions that have been brought up at this hearing so that there's a full understanding of what the commission is expecting when you come before us again.
Thank you. I think those questions will be very helpful to focus the conversation. And I also have the sense that this request by the commission doesn't add any undue delay to the process, because the process is, I understand it, and as you've described it, is really governed by what's going on with the county. So make haste. We encourage that. Thank you. Okay. I want to thank the parties for your being here today, and this part of our agenda today is closed. Thank you. Yeah, in consideration that lunch is unavailable, we're going to reconvene in 10 minutes for executive session. Okay, it's 12:03. Executive session is ended. We're back in normal session and we have no further business today. So this meeting is adjourned, 12:04.